offices in Virginia, Maryland, and Hyderabad. My main areas of practice include immigration, litigation, corporate. I do handle the MSCS audits too. And our today's topic will start with how the new regulations are affecting the students. And then as based on the audience request, we can look at the other topics, which are also equally important, the proclamation order. And then maybe if time permits, we can even go through the USCIS memo that affects the H-1B workers working at third-party locations. Okay, so at the end of each topic, I'll give you some time so that you can ask any questions related to the topic, and before we move on to the next one.
Yes, so thank you, Telugu NRI Radio. I believe this is being broadcasted live. Vilas, if you can confirm. Thank you. Over to you, Santhosh.
Yeah. So first, let's see what are the recent SVP modifications that are affecting the students, international students who are here on F1 and M1 visas. Okay. First of all, the SCVP stands for like a student and exchange visa program, visitor program. So typically, in order for any F1 student to maintain his status, they have to be enrolled as a full-time student, taking in-person classes. Of course, there are certain exemptions available wherein a person need not take full-time course, or they can take some online courses, but which should be part of their correct course curriculum. So with this new COVID situation, since most of the universities were not able to offer in-person classes, the SCVP program has made some modifications wherein students are allowed to take online courses for the spring and summer semesters, spring 2020 and summer 2020 semesters. We were under the impression that until the COVID situation changes, they would allow the same for the fall 2020 and maybe into the spring 2021 also. But to our surprise, last Monday, which is July 6th, SCVP has issued another memorandum amending the accommodations that were issued for the spring and summer semesters. So these amendments will go into effect for the fall 2020 semester, which is going to start next month. Okay, so this amendment, these amendments are going to be registered into the federal, will be stated into the federal register maybe sometime next month. But these, most probably, they may not make any changes to it yet unless they receive an injunction from the court. Right now, there are few court cases that are pending. One was filed by the Harvard University. The other one was filed by the California State. Of course, until a decision has been made on these cases, we cannot really depend upon them. So we're going to go through this memo and discuss how this will affect the international students who are here on F1 and M1 curriculum, M1 status. So these universities can be broadly categorized into three categories. One is those universities that offer 100% online courses. So there are a lot of universities, like especially the big universities, they do want to go with 100% online courses. And students who are enrolled into these programs are not eligible to stay in the country. They cannot. They have to leave the country, and they will not be eligible for F1 visa. So those students who are trying to come here for the first time and then applying for visas from abroad, they're not eligible to attend visas using universities which offer 100% online program. Further, those students who already have visas, even them, those students cannot come here because the CBP will not allow them to enter into the country using the I-20 from a university that offers 100% online program. So for those students, there are only a couple of options available. One of the options is to depart the US and then do the course from their home country, or to transfer to some other university which would allow some in-person classes. Okay, so I know some of the students may be asking, hey, if you leave the country and if you're outside the country for more than 5 months, then typically as their service will be terminated. But because of this COVID situation, they have made certain exemptions for such students when the service will not be terminated even if they have been absent from the country for more than 5 months, as long as they're taking some courses and working towards the completion of their coursework. Okay, and these students need not take full-time courses as required under the regular program. If they can show that if they can show that they have some issues in taking online courses, maybe because of internet connection or maybe the courses are not offered for the semester, then they have an exemption wherein they can take part-time courses. And students who remain in the US even after taking the 100% online courses, they could be put in deportation removal proceedings. So this is a very scary situation because especially for the master's level courses, right? So most of the US citizens who take master's level courses, they do work and study, and for them, it is not possible to attend classes. So there could be a lot of universities which may not allow any in-person classes because of this pandemic situation. Like for example, even Harvard, right? So they have modified all their programs to shift in-person classes to online courses, and they have trained. They have come up with all the programs. They have trained their professors and everybody to come up to be able to train the students online. And now they have to change their model within a short duration of time. Like they have only 1 month for the fall semester, so which could be a challenge. So the universities will be facing a challenge. The students, the F1 students will be facing a challenge. And also the US citizens, students will also be facing similar challenges because now they are forced to actually attend classes in person because some of the courses may not be offered online if the university chooses to give some exemptions so that in order to allow F1 students to stay in the country. So this regulation not only affects the universities, it affects the F1 students as well as the typical US citizen students also. Okay, and there are certain schools that are willing to open up and then allow the normal in-person classes. So for those universities, the SCVP has made certain changes which allows them to offer one online credit, one online course, which is equal to 3 credit hours. So out of the 3 courses, 1 course can be taken online from the regular schools. Okay. So now coming to the third category, which is a hybrid model. And as you know, most of the CPT students depend upon this hybrid model, which allows a mixture of online and in-person classes. Okay. So in those cases, the school has to make an attestation stating that the student is not taking 100% online course. Okay. And the student is taking minimum number of online courses, which will help them in completing their courses in a timely manner. Okay, so the universities are required to issue new I-20s starting August 24th or so, wherein they will have to provide all the information regarding the variety of classes that they are offering, whether it's online or hybrid model or in-person classes. So are there any students who are impacted by this, or can I answer the questions first before we go to the next topic?
Yeah, absolutely. I think you guys can unmute yourself to respond back to attorney. Or type in the chat window. Santhosh,
can you please? There are no questions in the chat window. If you have any questions, just unmute yourself and you can ask.
Santhosh, can you please repeat the question, please, one more time before we...
Okay, so if anyone has questions regarding the new SCVP modifications that affects the students, I'll be happy to answer at this point of time. I don't know if there are any students on this call who have questions. So if they have any questions, I'll be happy to answer at this point of time. Because I went through the overall information about the SVP changes that affects the international students. So I wanted to give some time if in case anyone has any questions regarding this topic.
I think we can continue and then people may ask.
So
There is a question.
If there are no students here, then maybe we should just go through the proclamation orders.
There is a question, Santhosh Garu. If we have hybrid class, will it get a new I-20?
Yes, yes. So most of those students, especially those who are on CPT, they will be having these hybrid models. So your university will be issuing a new I-20 wherein they will clearly state that you are not taking 100% online classes and that you're allowed to take more than one online course, but you have to take minimum number of online courses which will let you complete the coursework in a timely manner. Okay, so depending upon your school, you may be allowed up to 2 courses or 2 online courses and 1 in-person course. Okay, Malik, now do you have any further questions on this one?
Yeah, that's the only question we have. Yeah, you can proceed.
Sure. So then I guess like not many students are there in this call, so we'll discuss about the new proclamation orders and how it is going to affect the green card holders, the H-1B workers, and their dependents. Okay. So as you all are aware, because of this new pandemic situation, there has been a huge unemployment rate spike in the US. So in order to allow for a speedy recovery of the economic conditions and then labor market, the president has signed 2 proclamation orders, which will help in improving the labor market, so that and make sure that by making sure that the new immigrants would not compete with the US workers. Okay, so far 2 proclamation orders have been issued. The first one was issued on April 23rd. The second one was issued on June 22nd, which went into effect on June 24th. So for the ease of discussion, I'm going to categorize these as the first proclamation order and the second proclamation order. Okay. So the first proclamation order, it applies only to those individuals who are currently outside the US and applying for an immigrant visa. When I say immigrant visa, applying for green card applications. It does not affect those who are already in the US and processing their green card paperwork, whatever, like green card, or it does not affect anyone who is applying for labor, I-140, or any national interest waiver applications while in the US. Also, there are certain exemptions for those people who are applying for immigrant visas outside the country. If they are working in the healthcare industry or if they are working in the research industry, which helps in combating the COVID-19 situation. Okay. So also the proclamation order gives exemptions for those who are applying under the EB-5 program or and those who are actually spouse and children of US citizens. There is one main exemption that I want to make it clear. There is an exemption which allows those individuals who would be qualified as under the national interest waiver, and it's the consular officer who makes the decision whether you qualify for the national interest waiver. So if you are able to show that by you immigrating into the country, if you can generate more employment, then you could qualify for national interest waiver. So this is something that you can use if somebody wants to immigrate here, and then, but it is up to the visa officer to decide whether you qualify for this or not. Okay, so there is one major challenge in the first proclamation order is that it affects those children who are aging out, right? But when it came to the second proclamation order, so the first proclamation, at the time of announcing the second proclamation order, they have extended the first proclamation order with an exemption made for those students, for those children who could be aged out and would not be protected under the Child Status Protection Act. Okay. Again, these proclamation orders will be reviewed every 60 days, and also the proclamation order that was issued on June 22nd would be reviewed within 30 days from the day it was issued. So maybe before July 22nd, we will see another proclamation order. Okay. Does anyone have any questions regarding the GC, how it affects the GC cases? Because the first proclamation order is regarding the GC cases. So is there anyone here who's applying for a green card application, or if you who is actually abroad going to attend GC visa interview that could be affected by the...
One question, Santhosh here. Students who are stuck in India due to COVID situation, how does the new immigration rule affect them if they are on CPT and working from India for time being?
Good. So the SAVIS has released a notification actually soon after this memo was issued, and the notification clearly says that a CPT worker or a person on CPT or OPT is allowed to work from abroad as long as they can show that their employer is able to train and manage them, supervise them. Okay, and as long as your university is offering some in-person classes, and then you could be eligible for under the third category, and there is no bar for you to enter into the country. So if you're on CPT, you're attending some in-person classes, then you can come here. Okay, and the proclamation order also does not affect the student visas, so there is no restriction for them from that end. Okay, so now going into the second proclamation order.
So Santhosh, essentially it is the employer has to certify that the CPT student is well equipped with the training through the online.
Yes. So they have to attest that they are able to train the CPT student, even though they are and manage and supervise them, even though they're working from abroad.
So what material evidence is required to substantiate that claim, Santhosh?
So the employer has to keep all the training records and the email communications to show that they're actually assigning the work to the beneficiary, and also to show how they are able to supervise their work. Okay. So now coming to the second proclamation order. The second proclamation order actually affects most of the H1B visa holders, H4s, L1s, L2s and all. So the second proclamation, based on second proclamation order, H1B workers or their spouses, L1 workers or their spouses are not eligible to get visa stamping until December 31st. Okay, this is a big issue for those who are actually stuck in India without having H1 or H4 visa stamping. Okay, again, for these individuals also, there are certain exemptions. One of the main exemption is that if you are able to show that you would actually, you can qualify yourself, you can qualify under the national interest waiver, wherein then you would be eligible for H1 visa stamping even at this point of time. So, and those who are actually in the healthcare industry or working in the supply chain management would also be eligible for these exemption. One of the major thing that I want to make sure you understand is that if we are able to prove that your services are necessary for the immediate and continued economic recovery in the United States, then you may be eligible for getting a waiver. For example, if you're working as a project manager or a project lead, and if you are able to prove that your presence in the US will actually create more employment, right? And that your work cannot be performed by any other US worker, then you have a good chance of getting an exemption, which will allow you to get a H1B visa stamp. Okay, but again, this decision is made by the consular officer, and you will have to provide sufficient paperwork to the consular officer, wherein they will be able to in order to justify that you are irreplaceable. That means like there is no other US worker who can replace your job, and that your job will actually create more employment in the US and will actually help with the quick recovery of the labor market. Okay, and right now there is no ban on those who are trying to attend visas for F1 and B1, B2. So, but I know some of them may be thinking that, hey, I can come back here on a B1, B2 and later change my status to H1 or H4. I highly warn against this one, because the proclamation order clearly says that if somebody is trying to bypass the proclamation order through willful misrepresentation, all right, like for example, if there is a H4 individual who is stuck in India, they cannot get a H4 visa stamping, but they can attend B1, B2 stamping. So, and if they come here and if the officer thinks that the person is actually trying to just bypass the proclamation order, then they could be put in immediate deportation removal proceedings. So this is a very dangerous situation. I know typically before we have this proclamation order, as long as a person had the intent to not to immigrate at the time of entry and then they don't change the status within 90 days, we should be fine. But with this proclamation order, everything is going to change. I highly warn against anyone who is trying to change the status by after entering into the country on a B1, B2 or an F1 visa.
There is one more question, Santhosh Garu. How many courses can we take online on CPT?
Good. So you can take more than one course, but you cannot take all courses. So I would say you can take up to 2 courses, 2 online courses and 1 in-person course. Okay. The most important thing for CPT is that the courses, the online course or the training program that you are enrolled into should be an integral part of your coursework. Okay. Unless you are able to prove that, you will be violating your status. Okay.
Thank you.
Good. So are there any H1B or H4 individuals or L1, L2s who are affected by this proclamation order? Maybe I can answer your questions now.
I have a question. Hi, my name is Madhavi and Santhosh Garu.
Yeah.
Suppose oka individual ki H1 status lo unnaru. Aithe India elli he gets married. How can he bring his spouse? Will it be difficult to bring his spouse or?
Not at this point of time. It will be very difficult at this point of time until December 31st, because his spouse cannot attend the H4 visa starting now.
Okay.
Even the H1B visa holders, I would not recommend you to travel outside the country, even though you have a visa. So the proclamation order does not ban anyone with an existing visa to enter into the country. But we have had situations in the last couple of weeks where some of the H1B workers have been sent back, meaning those that their positions can be taken by any other US worker.
Oh, so it applies to individual.
I can't recommend anyone to travel on H1 or L1 unless it's dire emergency.
It's the same thing with CPT also, individual having CPT.
Yeah, anyone.
Oh, okay. Thank you.
CPT are a little better off comparatively, but H1s, H4s do not even try.
Okay. Thank you.
Yeah, you're welcome. Good. Any other H1B workers? Those who are on H1s here?
Santosh garu, inko question అండి ఇది. You explained little bit about the national interest waiver group అని చెప్పేసి ఒకటి explain చేశారు కదా. And they have to prove that they can potentially produce the employment here. So how does first of all, unless they are investing or they are trying to be entrepreneur in this country, the employment opportunities is little feeble, right? So if a person is coming on let us say any of the other non-immigrant visas, like H1 anukonde for example, okay, other than they can produce the employment, what other things that they can evidently produce to procure the visa status only?
So one of the things that they can do is, for example, it depends upon the individual, okay, the H1B individual. So if the individual is working in a position which actually generates more employment, for example, if the individual is a team lead, right, or a project lead, and without having a project lead, it's not possible to have the project, right? And then you'll not be able to hire the people underneath here. Because of his presence, right? Then because of his presence in the country, you'll be able to develop the product and then hire individuals underneath him. So these all have to be documented properly, and we have to be able to convince the visa officer. It's a visa officer who makes the decision whether you qualify for that exemption or not. So for that reason, I always of course, this is something that is happening for the first time. So some of the things that you could do is maybe obtain letters from your client or your employer and your employer to document that, okay, you are working in a certain specific position which cannot be replaced by any other US worker. That's first thing. And that without you being present in the US, they don't have a child, they'll suffer huge economic damage, or maybe they have to outsource the project, because of which they'll have to lay off more people, right? So if you can somehow document all this properly, and then if we are able to, if the H1B worker is able to explain this to the visa officer at the consulate, then there is a chance that he may be exempted. Because the only reason why they have this proclamation order is for the speedy recovery of the economic conditions here, right? So if we can show that his presence here would actually help with that, then there is a good chance that he will be exempted from the proclamation.
Thank you.
Okay, so they did not actually define everything in detail. So most probably we will receive a little more guidance on this in the coming months. Okay, and again, since the consulates are not open, not a lot of people have tried this too yet. So once things open up, then we can try this, and then I can give you a better picture.
Absolutely.
So
Santhosh, I have a question. So do the healthcare workers qualify for national interest waiver green card application provided with this current scenario of shortage of healthcare workers?
Yes, they do. So there is an exemption even in the first proclamation or in the second proclamation order also. There is an exemption for healthcare workers as well as those who are into the research in assisting with in combating the COVID-19 situation.
So is it the same national interest waiver timeline they follow, or is it expedited or something different?
Nothing is, it's not expedited. It's the same time, like there is no ban on those people.
And this is particularly for the green card application, not for the non-immigrant.
Are you referring to the priority dates?
No. Green card application. Yeah, obviously the priority dates. So
the priority dates thing, that did not change anything. No, that did not change. It remains the same as it used to be before.
Okay, thank you.
Yeah, so there is no preference given to the healthcare workers for the priority dates. It's the same thing as they were using before. So if a person is eligible for national interest waiver, then they would qualify for EB2, right? But still, the EB2 priority date for India is like you'll have to wait for like 10-15 years.
Okay.
Okay, unless a person qualifies for EB1 then it does not really make any difference.
Okay, thank you.
Okay, you're welcome. So let's like, does anyone else have any questions regarding the proclamation order? Okay, so let's go through the June 17th memo, which actually gave a lot of safe haven for for H1B workers, especially those working from third-party locations. So previously, we used to follow the Jan 2010 and February 2018 memos with reference to showing the employer-employee relationship as well as the availability of specialty occupation work in order for obtaining H1B visas. So with this new memo, everything has changed. So the new memo suspends the previous two memos, which makes it very easy to get H1B approvals for now. So all those individuals whose H1Bs are expiring in the next 6 months, I highly recommend that you apply for the extension of status as soon as possible before any new regulations go into effect. Okay, because right now it's easy to get H1B approval, and that too for a full term, a full 3-year term. Okay, so now with this new memo, you are not required to provide a client letter or a vendor letter or agreements to show availability of work. Okay, you may still need the client letter sometimes only to show that the position requires qualifies for specialty occupation, which requires a minimum of a bachelor's degree, but that can be done through other means also. So now it is not mandatory to provide the client letter or vendor letter or any of the agreements. This has been evident in the recent past because for most of the CAP cases and other cases that got approved in the recent past, they were all approved without RFEs. When I say RFEs, we received RFEs, but only for related to their non-immigrant status, like F1, like OPT or CPT issues. But most of the cases got approved for 3 years. So before any new regulations go into effect, I highly recommend those whose I-94s are expiring anytime in the next 6 months should apply for their extensions as soon as possible. Okay, and also
question, Santhosh Garu, is this applicable for new H1 applications as well?
Yes, yes.
And also in-house filing applications as well?
Yeah.
Thank you.
Yeah. So for most of these cases, right? They are approving the cases as long as you're able to prove that the person qualifies for specialty occupation. Yeah, but again, this could change anytime. Right now, this is the best period for anybody to file their H1s. In that way, they can get approvals for a longer period. Is this for in-house? Yeah, in-house you have to see, it's although you don't have to provide all the agreements and everything, the employer has to attest that they have a project available for the beneficiary at the time of filing the case. So a person cannot be filing a fraudulent petition, but as long as you have a project, then you can file the petition. It's easy. It's much easier to get approval now than it was a few months ago. Okay. Another thing that I want to discuss is that H1B workers are allowed to work for 2 employers at the same time. So there is an option where H1B workers can file for a concurrent H1B and work for 2 employers. Okay. Does anyone have questions regarding the concurrent employment, wherein which allows the beneficiary to work for 2 H1B employers at the same time? Okay.
Is that something new, or is that
No, it's been for a long time, but people have not been using it. But with this COVID situation, right, since everybody is working from home, so now they have more flexibility to work for on 2 different projects.
Wow. And
so a lot of people are working. That's the reason why a lot of people are filing for concurrent H1s in the recent past. Before then, like we never used to see so many concurrent H1B cases, but now they have increased.
So Santhosh, the bipartition bill that was introduced, is that different than the national interest waiver for the healthcare workers, or is it the same? Like if this bill is passed, then they will have another path for the healthcare workers?
Well, they may be, like, so this is a problem. Even if the bill is passed, right, it doesn't say that they will qualify for EB1 directly. Okay, so for like even if it is like they're right, even now also they're categorized as EB2, but the issue is for people who are born in India, not for everybody else.
Okay, because of the nationality, right?
Yeah, that is the issue. So even if they pass the bill, it does not mean that it's going to directly help those from those born in India.
Yeah. Okay, thank you.
The only bill that is going to really help us is if they pass a bill stating that anyone with an approved I-140 can immediately file for adjustment of status and thus apply for employment authorization as well as advance payroll. That will only help. That is the only bill that will really help Indians.
Sure, thank you.
You're welcome. There is so in the recent memo, there is one issue that was raised.
What is the question? Looks like.
Yes, one question, sir, on the EAD, on the H4 EAD. So my H1 got approved in March. H4 EAD is still, H4 and H4 EAD still under regular processing, and biometrics is also not done. This is the first time we are doing biometrics. Do you think can we expedite that H4 EAD?
No, unfortunately.
Employer is not giving any letter, but showing any financial issue. Can we expedite the H4, writing a letter to USCS or reaching out to congressmen, local congressmen? Can we do that?
Yeah, I'll tell you. So a H1B worker would not have financial issue. Okay, as per the typical median income of the country, H1B workers get paid much higher than the average income, right?
Right, but H1 is approved. The question is about H4, sir.
That's what I'm trying to say.
H4 and H4 EAD.
H4 EAD will take some time because you have to go through the biometric process, and then the biometrics. So if it was an extension, right, then they would be able to
extension. It's an extension, sir. It is extension. So so the current EAD is expiring in August 15th.
No. Did she attend biometrics before?
No, this is the first time, because last time there were no biometrics when we got in 2017.
Yeah, that's true. So typically, if they already have their biometrics, then there is a chance that they would have approved the H4 and H4 EAD. But if they don't have it, then we may have to wait for some time. And there are a lot of.
What is your feeling that considering July 11th to August 15th is expiring, and we applied in March, and so far biometrics is not done yet? What do you think? How much will be the timeline? Because due to the COVID and everything, is it because just to prepare? Because until August 15th it is not renewed, then we can at least tell the employer approximate timelines and get a medical leave or something. What is your advice here, sir?
It is taking much longer time. Which is
maybe another 6 months or like 3-4 months?
Maybe another 3-4 months.
Okay, another 3-4 months. Okay. Once the biometrics is done, can we expedite in that case? I assume like biometrics is done August first week. Yeah. At that time, do we have a chance to expedite?
Yeah, once the biometrics are done, then there is a chance that you may be able to expedite it a little bit. Okay, but again, if it is it could be within the normal time frame also, because there are a lot of cases that have been pending. Even we filed quite a few number of H4 EADs in the month of March. They're still pending.
Okay.
The H4 by then, before they got the H4 biometrics, the court situation happened. So I don't think most of them they not even get the biometrics first yet.
Okay. So right now. So right now, sir, from your advice, we just have to wait and watch until we get the biometric appointment. Once we have the biometrics, then we have a probability of increasing it. I mean, expediting it, right, sir?
Yeah. So maybe you could have her employer reach out to the senator saying that, hey, we need this person, and then if not, we'll be incurring like whatever, we will not be able to complete the project or whatever, and then you could put some pressure. But again,
do you think that without biometrics, if we put the pressure from the employer, is there any probability that this get approved?
First, right? Without approving the H4,
yeah.
the H4 EAD.
Okay, got it, sir. Got it. Sir, I have a second question if you have a minute. So if you are under EB2 category, and if we go outside for 1 year and work as a manager and come back, we can file EB1, right? As per the company policies and immigration. Can we put the EB2 date when we are filing a EB1, or is it going to be a fresh new EB1 with a new date?
Yeah, you can put the date. There's no issue with that. You can put the date from
okay, we can
EB or EB2 to EB1. There's no issue with that.
Okay, thank you, sir. Thank you.
As long as the initial I-140 is not a fraudulent one, you should be fine. You should be able to put the priority data.
Okay, thank you, sir.
And another thing regarding the bench. Okay, so if a person is in between jobs, then the employer is required to file an amendment updating USCIS stating that they are no longer working in the specialty occupation. This is a new trend, and I'm sure there will be another litigation on this one. But even if the employer is paying the salary when the person is on bench, still the person will be considered to be out of violating his status because he's no longer working in the specialty occupation position. So the employer will be required to file an amendment to update that the beneficiary is no longer working in that specialty occupation position, but getting some training or whatever. Okay. Also, an employee, any H1B worker has to be continuously getting paid unless they take a voluntary leave, or if the person is taking like a disability leave or family medical leave, but that is only allowed if it is part of the employer's benefits program. Okay, so a H1B worker has to be getting paid continuously whether a person is on project or without the project. And they have to get paid until the last day that they work for that employer. An employer cannot withhold your payroll even if you owe them something, or maybe you violated some of the agreements, whatever, right? Whatever is the case, or maybe you have their laptop with you. Still, they have to pay you until the last date. If not, it's a Department of Labor violation. Okay, so I know we have 3 more minutes. Does anyone else have any questions?
At this point, there are no more questions in the chat window. Do we have anyone from the leadership, Gangadhar garu, on the call to give the closing comments?
I think like we do not. I think like we do not have anybody, but I think like we have the other standing committee leads here, Ashok Garu and Srini Garu. Srini Garu and Ashok Garu, would you like to have a few words before we close? Before we get back.
Santhosh garu, namaskaram andi. This is Ashok Kumar from New York.
Namaskaram.
Thank you andi. Very informative session. Janalu chala tension ga unnaru, as you know, right? Every day kotta rules vastunayi. So position lo manam unte kuda itle panic ga untuntimi. But I hope who are really facing this situation, I think this will be very helpful immigration seminar అండి. Thank you very much. And Mr. Malik and Gangadhar garu, thank you for arranging this informative conference call through Santhosh Reddy garu.
Sure. Srinivas Gudur garu, do you want to have some comments? Closing comments? And Vilas, thank you for covering this live on NRI Radio. Thank you, Santhosh garu. I think a lot of students will be benefited, and we have this recording, so we'll save this recording and we'll communicate it to several folks so they can be getting benefited. And also, if you want to share your details or anything,
Sure.
That would be, maybe if anyone have any questions in future, like a consultation help, they could come. Srinivas garu, yeah, can you provide closing comments, please?
Me, Guduru?
Yeah.
Salaman Srinivas uన్నారు. Yeah, thank you so much, Santhosh garu and Shaila garu, for accepting our request, for providing this very valuable information in a timely manner for our student community. Really appreciate your time, and very well articulated. And I think it clarified a lot of doubts that were posted online. And once we post this online, share this recording, it will answer, for many people. I really appreciate it. And thank you, Gangadhar garu and Ravi, for taking it up and giving a shape to benefit our student community. Thank you so much.
Thank you, Andy.
And Monica, good concept. You seeded this. Appreciate that.
Thank you, Santhosh garu, for valuable inputs. I think you cleared most of my questions. I can forward to all of my friends, whoever asked me those questions. And really, thank you for your time. Thank you, TATA.
హాయ్ అండి, సంతోష్ గారు. నా పేరు మాధవి సులేటి.
హాయ్ మాధవి గారు.
విమెన్ చైర్, టాటా విమెన్ చైర్ అండి.
హాయ్ మాధవి గారు.
సంతోషం అండి, మీరు చక్కగా చెప్పారు, చాలా వివరించారు, అంత డీటెయిల్డ్ గా. యాక్చువల్లీ నేను వేసిన క్వశ్చన్ కూడా మా ఒక బెస్ట్ ఫ్రెండ్ అబ్బాయి ఇక్కడ H1 లో ఉండే. సో దట్ వాజ్, వాళ్ళు చాలా డౌట్స్ లో ఉండే అసలు పెళ్లి చేయాలని ఇండియాలో. సో వి క్లియర్ ద డౌట్, వీ గోయింగ్ టు పాస్ ఆన్ ద మెసేజ్. ఎందుకంటే ఇండియాలో మా ఫ్రెండ్స్ వాళ్ళు వరీ అవుతుండే అబ్బాయి పెళ్లి చేయాలని. అమ్మాయి వెయిటింగ్ లో ఉంది అక్కడ అందుకని. సో చాలా క్రూషియల్ టైం ఇది, చాలా చక్కగా అన్ని బాగా ఎక్స్ప్లెయిన్ చేశారు. వి గోయింగ్ టు పాస్ ఆన్ ద మెసేజెస్ టు అవర్ ఫ్రెండ్స్ టు. థ్యాంక్ యూ.
Once again, thank you all for joining this call. I know, last minute lo, I know it was supposed to be tomorrow, and then due to some personal reasons, I cannot make it tomorrow. So
yeah, it worked out well, Andy.
Thank you so much, Santhosh garu. Thanks for your time and valuable information. Over to Gangadhar garu.
Absolutely, I think thank you all the. Go ahead, Madhavi garu. Go ahead, and Madhavi.
Sorry for interruption. Meeku thank you for coming up, Monica, Gangadhar garu, Malik garu. Very thank you. Right time, thoughtful webinar ide.
Thank you.
Thank you very much, Madhavi garu. I think if is any of the other TATA leadership we missed, please raise your hand. We don't want to miss anybody. But I think Srinivas garu, Ashok garu, Madhavi garu, and everybody, Monica garu, thank you very much.